The Supreme Court on Wednesday held that a divorced Muslim woman can demand maintenance from her husband under Section 125 of the Code of Criminal Procedure, as well as the Muslim Women Protection on Divorce Act 1986. Now, you'll hear a lot of news around this judgment, I'm sure, but why is this significant? What do these two laws say? And what has the Supreme Court said in this judgment? I, Apoorva Mandhani, will tell you in this video. Now let's understand the law here first. We have section 125 of the CRPC, which talks about maintenance of wives, children and parents, saying that if any person with sufficient means neglects his wife or parents or children, who is in this case wife, if it's the wife who is unable to maintain herself, then the court can order such a person to pay the wife monthly allowance for her maintenance. As for the 1986 Act that I mentioned earlier, let me give you a bit of background first, because this issue has in the past been extremely political. Essentially, the Supreme Court in the 1985 Shah Bano case declared that section 125 of the CRPC, which I just told you about, applies to all citizens irrespective of religion. This was of course a landmark decision in India's constitutional history. It involved complicated questions about the role of a secular state in matters of religion, as well as the intersection of religious principles and individual constitutional and fundamental rights. The issue, as I said, was highly politicized back then, with then Prime Minister Rajiv Gandhi overturning the effect of the Apex Court decision or diluting it by passing the Muslim Women Protection on Divorce Act 1986, which restricted maintenance to divorced Muslim women to the iddat period essentially. Section 3 of this law talks about the meher or other properties of Muslim women to be given to her at the time of divorce, and it says that notwithstanding anything contained in any other law for the time being in force, a divorced Muslim woman would be entitled to maintenance paid to her within the iddat period. This was among other remedies that this 1986 law provided for. And after this law was passed, several petitions were filed challenging its constitutional validity before the Supreme Court on the ground that it violates various fundamental rights under the Constitution. Now, in a judgment passed in September 2001, the Supreme Court upheld the constitutional validity of the law, but interpreted it to mean that a Muslim husband is liable to make reasonable and fair provision for the future of his divorced wife, extending beyond the iddat period as well. However, the High Courts then took varied views. The first view was that the remedy for a Muslim woman has to be exclusively excised under Section 3 of the 1986 Act, while a few other judgments allowed a divorced Muslim woman to seek the remedy of maintenance under Section 125. Now, the judgment was passed on Wednesday by a bench comprising Justices B.V. Nagaratna and Augustine George Massey. The two judges pronounced separate but concurring judgments, affirming that Section 125 of the CRPC applies to all married women, including Muslim married women. The Supreme Court has ruled three major things. First, it has said that a Muslim woman can demand maintenance from her husband under Section 125 of the CRPC, as well as the Muslim Women Protection and Divorce Act 1986. It has said that the option lies with the Muslim divorced woman to seek remedy under either of the two laws or both the laws. In his judgment, Justice Massey explained that Section 125 is a measure for social justice to protect the weaker sections, irrespective of applicable personal laws of the parties. Meanwhile, Justice Nagaratna also spoke about the vulnerability of married women who do not have an independent source of income. In fact, Justice Nagaratna said in her opinion that maintenance is a facet of gender parity and enabler of equality and not charity. The court has even clarified that in a case where a husband has fulfilled his obligations under Section 3 of the 1986 law or as provided by customary or personal law, the divorced Muslim woman can still subsequently invoke Section 125 on the ground that she is unable to maintain herself. When a husband opposes such an application, of course, he has to establish that A, his initial obligations under the customary or personal laws are fulfilled by him, and B, that the wife in the light of this is able to maintain herself. This is what the husband will have to show. The court clarified that if a reasonable substitute has been provided for by the husband as per their personal or customary laws at the time of divorce, the maintenance provided by a magistrate or family court under Section 125 can be reduced accordingly. So, it can be adjusted depending on what maintenance a Muslim woman is getting under the 1986 Act as well as under Section 125. The court also highlighted provisions of Section 127 of the CRPC, which allows alteration in allowance payable to a woman, explaining that when an order has been made under Section 125 in favor of a woman who has been divorced from her husband, the court can cancel such an order if the woman has received an amount payable to her under any customary or personal law applicable to the parties. The court then explained a scenario when a divorced Muslim woman initially moves a petition under Section 125 seeking maintenance and exercises her rights under Section 3 of the 1986 Act after getting maintenance under Section 125. Then in such a case, it said that if the husband fulfills his concerned obligations ensuring her future maintenance, he can approach the court under Section 127 that I just spoke to you about, that allows alteration, seeking cancellation of the order first passed in her favor under Section 125. So there will be an adjustment and a harmonious interpretation essentially of the two sections. Third, the Supreme Court also spoke about a case of an illegal divorce as per the Muslim Women Protection of Rights on Marriage Act 2019, which essentially prohibited triple talaq. This law was much spoken about when it was passed back in 2019, and Section 5 of the 2019 law talks about subsistence allowance and says that a married Muslim woman who has been given triple talaq or any other instant talaq is entitled to receive subsistence allowance for her and her dependent children. The court now explained that in such a situation, the woman can seek relief under Section 5 of the 2019 law or under Section 25 of the CRPC, again giving her the option. This is again important because there wasn't a clarity especially on this issue as well so far. So these are the three major things that the Supreme Court said in its judgment passed on Wednesday. That's all I have for you today. This is Apoorva Mandhani for ThePrint. For more such videos, do subscribe to our YouTube channel and follow us on Twitter, Instagram and Facebook.